All right. Well, we'll go ahead and bring Judiciary Non-Civil to order for today. And Caucus Vice Chairman Gravely is going to lead us in our invocation. So, Caucus Vice Chairman Gravely, will you hit your button, please? There you go. All right.
All right. Good afternoon, everybody. Let's go to the Lord in prayer. Father God, we thank you for this day. And Lord, though sometimes we think we've got enough, we thank you for the rain as well. We thank you for this committee and all families represented in this room today. Lord, lead, guide, and direct us. We ask these things in Jesus' name. Amen.
All right. So as an initial matter today, I want the committee members and the public that's here to know that there's a proposed substitute to House Bill 994, which will be presented by the committee here today. I understand that those in attendance might want to have a copy of it to take a look at it. So as available, Kyla Miller is going to make copies available of it if you would, if there are any extras maybe, and if you all would be willing to share your copies so that just until we can have the copy machine make us enough, that'd be helpful. But I wanted you to be aware of that before we put the sign-up sheet out, and maybe if you would take a look at the substitute and then make a determination as to whether or not you might want to sign up. We are planning to take public comment on that bill today, but that would just be the invitation that we would make for you. So at this point, I see Representative Williams is present. Representative, would you like to go ahead and come forward to the podium? We will call for either your pleasure, the podium or the table, whatever you'd prefer. But we'll go ahead and call House Bill 983 for hearing at this time.
Thank you, Mr. Chairman, members of the committee. Bring before you this House Bill 983. Milledgeville, Baldwin County is a little unique, always has been, I guess it always will be. What we have there now is a domiciliary nursing home for convicted prisoners that have been paroled, and it's kind of a nursing home in the last place before they leave this earth. What happens there, we have about 85 sex offenders. So what this does, it has our sheriff making 4 or 5 trips a week to this Bostic building, and they're about to build another one. What happens is the Department of Corrections actually paroles these offenders, and they are no longer wards of the state. They become committed to this facility, and their medical care is paid for by Medicaid and Medicare. So they're no longer being paid for and kept up by the state. But these sex offenders, and our sheriff has to make countless trips out there, and it just becomes more and more frequent. And with expansion that they're anticipating in the additional building to be built, he may be going out there 7 days a week because they're required to go, I think, on their birthday to reaffirm where they are. But we're asking for something just to change it so that he can go once a month to secure and to know where these people are and to reaffirm it. And it would just save our sheriff a whole lot of work and a whole lot of time and a whole lot of money. And he can be doing the other things that our sheriff does. I ask for your consideration. Be glad to answer any questions if you have any.
All right. Is that Representative Chairman Silcox, number 25?
Yes,
Thank you,
ma'am.
Mr. Chairman. Representative Williams, thank you for bringing this bill. I appreciate what you're trying to do. I guess help me understand what changes we would make specifically.
Well, what the sheriff has to do now is on someone's birthday, if I'm not mistaken. And could Terry speak to that?
Sure, that'd be great.
Uh-huh.
Yes, sir. Mr. Norris, if you'd like to come forward and sit at the table, that would probably be best. And committee members can pose questions to either Mr. Norris or Representative Williams.
Well, thank you for the question. The Sheriffs are responsible for registering sex offender in this state, registering, monitoring, tracking sex offenders in the state. There are about 33,321 sex offenders in the state as well at this time. 985 are predators. There's about 600, almost 700 absconders, meaning we don't know where they are, so they're here or somewhere else. But the sheriffs, they register once they are released from prison or placed on probation, and then annually thereafter on their birthday, or within a day or after their birthday. And this bill simply addresses a confined number of sex offenders. Confined, by that I mean they are bedridden, most of them, in a nursing home type facility that is contracted with the state. For the sheriffs, there's about 170, and that number has changed a little bit. It goes up and down in this one facility. And as Representative Williams mentioned, 85, and this morning I checked, it was 90. 90 of these people are sex offenders, meaning they can't get out and come to the sheriff's office and register, most of them. So this will allow the sheriff to come and register those people in this bill. The language in this bill is during their birth month, which means if you think about it, if you've got 90 people being registered, those birthdays are all assorted dates. So this will allow the sheriff to come 12 times a year instead of daily.
Okay.
Second part of the thing, Mr. Chair, is the fingerprint aspect. Many of these people are, it's very difficult to even get a print from them. We all have all of their prints now, so that annual print requirement for those confined people would be at the sheriff's discretion. Some of those folks are actually withered to the extent that they really can't get a good print on them anyway.
Wow.
So, thank you.
Okay, thank you.
Representative Sains.
Thank you for bringing this bill forward. It's definitely necessary. I have no issue with the bill. I just ask if I know there's similar language that was requested to be added to House Bill 720. So if there's anything, if this bill does pass, if there's any issues y'all have with that parallel, if it needs to be stricken out, just get with me and I'll make sure that there's no conflict with it.
Thank you.
Thanks.
Thank you, sir.
All right, any other questions for the sponsor or Mr. Norris? All right, hearing none, I'll entertain a motion. All right, there's a motion do pass from Representative Sains. Is there a second? All right, there's a motion and a second. Any amendments? Further discussion about House Bill 983 is introduced, LC 289625. All right, hearing none, all those in favor signify by saying aye. Aye. Any opposed? All right, it passes unanimously. We should have some Rules Committee forms available in here. If you would just make sure your Rules Committee form is submitted to my office by the end of the day, I'll make sure to sign it and get it to Chairman Smith.
Sure will.
Great, thank you,
Thank you,
Representative.
Chairman.
Thank y'all.
Thank you, Mr. Norris. All right, so at this point in time, we will go ahead and proceed with House Bill 994. In the folders here, you can see a proposed substitute and the bill is introduced, I believe is also in your folders, so you can compare them. All right, so as this is a committee substitute, I'm happy to walk you through some of the proposed changes that are included in this. Sections 1 and 6 as introduced are not in the committee substitute that is before you here today. Section 1 would now, or what is in Section 1 of the substitute, would require that the court hold a hearing on a motion by a district attorney to transfer a case to the Superior Court. And this language, as I understand it, is in fitting with the objective of ensuring that the most serious cases in juvenile court are given due consideration. And as far as consideration in Section 2, you'll see on line 68, the court may consider evidence of a child's participation in a gang. So that's a new point of consideration for the juvenile court judge. On Section 3 of the bill, you'll see proposed language that really goes to our objective here, as I understand it, and that is for juveniles who have been charged with gang offenses should be treated so that they can be de-brainwashed, so that they can be removed from that mindset, so that they can grow and become productive members of society. And I think that this substitute really works to incorporate language to emphasize the need to ensure that children receive treatment so that their gang involvement does not lead to further criminal behavior and does not hamper them from being successful otherwise when they reach adulthood. That's the objective with this language. And I think we'll have a discussion about that in a minute. The remainder of the substitute is language as introduced in the bill, aside from what I mentioned earlier. Sections 1 and Section 6 have been removed from the bill as introduced. So I know that we have the sign-up sheet out now, and I appreciate the interest of members of the public who might want to give input on this bill, but as the discussion goes today, we might have kind of a free flow of conversation with the chair calling on specific advocates in the room who can maybe speak to specific provisions of the bill and provide guidance to the committee members as we look through the substitute here today. So at this point in time, if it's all right, and Ms. Dodson, if you wouldn't mind moving the sign-up sheet to maybe on the bar right there, so that I was going to ask Commissioner Oliver if you could please come forward to speak to really Section 3 of the proposed bill. Which would you prefer? Okay, the table would be great then. All right, thank you. So, Commissioner, if you would just introduce yourself to the members of the committee and introduce the Vice Commissioner who's with you today. Thank you.
All right. Thank you, Chairman and committee members. My name is Tyrone Oliver, Commissioner of Department of Juvenile Justice, and I'm here to speak in favor of this bill. And I also have Deputy Commissioner Margaret Kaywood, who's in charge of our programming and support services, and she's going to speak especially about what you just mentioned about the servicing our youth and adolescents.
Thank you. Yes, ma'am. If you would just take us to the lines of the bill that you want to discuss. Yes, ma'am.
Thank you. And it's Section 3, Number 6, and our recommendation is to change the language to say, shall participate in an evidence-based intervention program that has demonstrated efficacy in addressing factors that impact adolescent gang involvement. And the reason for that is that we would want to be sure it's evidence-based following national research practice of what's effective specifically to address the underlying reasons that the adolescents were involved in gangs, and specifically to address adolescents and not to be considered with adults, because we want to consider the adolescent brain development and adolescent positive youth development.
So if you would, can you just walk us through the what these treatment programs entail for a 13 to 16-year-old who is in juvenile court for a gang-related offense, and what this treatment might entail to work to rehabilitate and ensure that there's no further infractions or violations of the law?
The current evidence-based programs that we use now, and what the national research indicates, is that youth have thinking errors, that they have not learned to think correctly, and then they also have poor social skills, poor problem-solving skills. And so the focus of the group, such as anger, aggression, replacement training, thinking for a change, those are some evidence-based programs that are very specific to addressing the reasons that adolescents get in gangs, and the underlying reasons tend to be around the sense of wanting to belong, to financial security, safety, and their inability to cope or problem solve in the situations that they find themselves.
All right. All right. Any questions for the Commissioner or Vice Commissioner? Representative McLaurin.
Thank you, Mr. Chairman. Is there a way, and I'm maybe evidence-based is a term that does this, to specify which programs exactly? I mean, is that like a term of art that refers to only a certain subset of programs?
Yeah, evidence-based, there is a national definition for that, and it basically means that the research nationally has demonstrated for this population of focus that it produces the desired outcomes. So there is a specific definition.
Okay. And I assume if you're going to propose some language, it's going to tether it to that specific national definition.
Absolutely.
Okay, great.
And actually, evidence-based is already in the juvenile, in the code around Department of Juvenile Justice responsibility to provide evidence-based programming.
Okay, great. Thank you.
So I will just state the proposed amendment that could be made later in the process so that you all can make notes if you'd like as to that. It's on line 85. Begin deleting the word "a" through the end of that sentence with "gang" on 87, and replace, so "a" to "gang" is removed, and replace it with "an evidence-based intervention program that has demonstrated efficacy in addressing factors that impact adolescent gang involvement." Is that correct?
Correct.
Thank you. All right, any other questions? Thank you very much. Thank you both very much. All right, as we typically do, we're interested in receiving any input from witnesses, and our standard groups that we generally always hear from would include the Prosecuting Attorney's Council and the Georgia Association of Criminal Defense Lawyers. If it's all right, maybe I would look now to Mr. Skandalakis and the Prosecuting Attorney's Council if you'd like to come forward, and if we could maybe ask you some questions about the proposed legislation. That's excellent. I see Mr. Cranford here. Mr. Cranford, would you be willing to come forward, please, and maybe we could ask you some questions? Would that be all right? All right, Mr. Cranford, if you would just introduce yourself, please, and then tell us any comments that you have, and we'll probably have some questions. Thank you.
Thank you, Mr. Chairman. My name is Herb Cranford. I'm the DA of the Coweta Circuit. That's Coweta, Carroll, Troup, Meriwether, and Heard counties. I wanted to speak to specifically the venue provision. I have some concerns about the way it's currently worded, and I don't think that was changed in the version we received.
So we're on page 9. It's of the substitute, so it's lines 279 to 283, I believe. Is that right?
That's correct, Mr. Chairman. I would like to say I'm supportive of the overall thrust to improve the Gang Act so we can aggressively prosecute criminal street gangs. We do a lot of that in our circuit. I've done it as an assistant DA. I am in favor of a venue provision that would allow district attorneys in different judicial circuits to agree for one or the other DA to have jurisdiction. The concern I have about this language is some other DA could either be more lenient or more harsh than I and my constituents think are appropriate for any given case, and they could do what they wanted with the case no matter what I thought about it. I think it's too open of a door right now, respectively, given this language, but some qualifying language I think could fix that, and if that was added or changed, I think a lot more DAs would be supportive of it. I think just right now, a lot of DAs have concern about what that might mean in the future, you know.
All right. Is it fair to say, if I understand the concern, is it fair to say that if hypothetically there was gang activity that was being perpetrated in multiple counties, that there might be very different treatment that occurs depending on the judicial circuit and that this provision would allow one judicial circuit to effectively have the final say on the entire activity.
Yeah, so from my circuit, my concern, because we try to be pretty aggressive with it, is that let's say there's one defendant, he's committed crimes in 2 adjacent circuits. Well, a smart, hardworking defense attorney might go to the DA of the other circuit and say, look, we'll plead guilty to what happened in your circuit and this other circuit if you give us some sentence that I would think is too lenient for the crime that happened in my jurisdiction. And, if an ADA made the decision to do that, I think they would have the authority to do that under this bill. And they could cut a deal very quickly. And then, maybe while my law enforcement is taking months to do, what are very intensive, complicated gang investigations, all of a sudden I found out my charges have been resolved in some other jurisdiction. So that's the concern. And again, I think it could be addressed if the affected DAs had to have some kind of agreement, because I do think it would be very valuable. I've handled, and we continue to handle, a lot of cases where, for example, a gang member steals a car in some other jurisdiction. They call them slider crimes, I think y'all have heard about. And then they'll come to Coweta County or Meriwether County and do, an armed robbery with that stolen car. And I do think it would create a lot of efficiency and be more effective if I could talk to the adjacent DA and say, look, what do you think about me handling the original theft out of your circuit along with the armed robbery that occurred in my circuit? And if he or she, that DA, was agreeable to that, then I think that would be a helpful tool in the tool belt for gang prosecution.
All right, there are a few questions.
Yeah.
Number 16, is that Representative Bodie? Whit Bodie?
Thank you so much, Mr. Chair. Thank you for testifying today. The idea that you have is a very, very, I would say, idea that could be something that this committee could take up. My question to you would be, how would, logistically, how would we do that? Would it be a situation where a motion could be filed in one of the counties or within that circuit, file it with a particular judge who may have the most severe charge, and maybe some type of consent order is done between counties, or just maybe in the case that when DAs recuse themselves, sending something to the AG's office, just logistically, how could we do that? Because I think you may be on to something, but we need to put it in code.
I agree. I think there are probably a few ways to do it, and to be frank, I'm spitballing here in light of your question, but a comparable mechanism that we use is a defendant can waive venue to plead guilty to charges from different jurisdictions, and that just requires the defendant signing a document that's filed with the respective clerk of court. So I think it could be as simple as, I would want the authority to come only from the elected DA, not an assistant DA. So I think it could be as simple as, using the hypothetical I was using, if the elected DA could sign and file some document that refers specifically to the defendants involved and, the on or about date of the crime in question, somehow to be particular enough to make sure we're talking about, the same incident, and they could say, something to the effect of, they're agreeable to, or whatever language, to the DA of the Coweta Judicial Circuit prosecuting, said crime and said person. I don't know that it would have to involve an Attorney General's office, or I think it could happen in a county courtroom or clerk's office.
But we would still have a pleading actually filed with the clerk of court, either a pleading or a waiver, correct?
I think that would be doable. I don't think that would be too heavy of a lift, and I think having something in writing where there can't be confusion, So something more than just, I had a phone call with another DA, I think would be a good idea.
And you're amenable to that authority only coming from the elected DA and not a line prosecutor, correct?
Yeah, I think that would be wise. You keep some assistant DAs from, making a mistake or something. Yeah.
Thank you, Mr. Chair.
All right, Representative McLaurin.
Thank you, Mr. Chairman. First off, I want to start by saying hello to Mr. Cranford. I think for the first time in 12 years since we were in a religion class together at the University of Georgia.
I thought I recognized you and I couldn't.
Yeah.
Yeah.
So it's good to see you again.
Yeah, good to see you.
In the meantime, you have developed a lot more criminal law expertise than I have, so forgive me if this question is off. But my sense of how venue works is you want there to be, the policy behind it is you want there to be some connection between the forum and the crime committed. Mm-hmm. And so for me, and this is just, riffing, explaining what I'd like to see in the bill, I'd like to see a limitation on this provision that would only allow venue outside of where a crime was committed in the case of a crime whose nature was to occur in several jurisdictions, like, for example, sex trafficking, kidnapping, that sort of thing, right? And so I guess my question would be, if this bill were to limit this venue expansion just to those two crimes, that would solve a great deal of the issue that you're bringing up, right, concerning the prosecution of other crimes that aren't covered by those two.
I guess it would necessarily limit it because we're only talking, in that scenario, we'd only be talking about a couple of crimes. I will say the nature of gang crime, in my experience, is it is multi-jurisdictional. We've got people, like I alluded to earlier, committing crimes in one county. In our circuit, we're 5 counties. We abut counties with large metropolitan areas that have substantial gang crime. And we're regularly dealing with people coming from other counties. And we try to coordinate those prosecutions anyway. So it's not unusual for me to contact, I don't want to name any other counties necessarily, but just adjacent counties to my circuit, for the prosecutors to talk and say, here's the plea offer I'm making on my case. What are you trying to do? And we'll try to work out global resolutions, which can be tricky because defense attorneys want to make sure they've got everybody in the same boat. So I think having a broader venue for all gang crime would be valuable as long as there's a check in place. And my idea was, the respective DAs having to agree.
Okay. Well, appreciate you being here and good to see you.
Yeah, you too.
Mr. Cranford, if I could ask you a few questions. So if you flip to page 8 of the bill, this is the end of section 5.
Mm-hmm.
So this is just an amendment to the criminal gang statute that would provide that the offense shall not merge with any other offense. And I'm recalling back to my days as an assistant DA, and merger would really only occur if 2 offenses would otherwise occur without this language. If the 2 offenses had the same elements, is that correct? The exact same elements?
That's correct. I think there's also such a thing as factual merger. So I had a case one time, the commission of an aggravated assault also caused a substantial injury, and that being one act required the aggravated assault and the aggravated battery to merge. Okay. So it can get a little trickier than what you said, right, but I think you're right.
So I guess my question is, how would this provision impact sentencing if consecutive sentencing might still be available? So in other words, if, say, there's an underlying offense and then the criminal gang offense is also charged, could not there be consecutive sentencing for those 2 charges that would allow for the same result as what is outlined here for merger?
I think that courts have already begun to interpret the old language such that they're not required to merge. I think this is making it clear that they cannot merge. I don't know that I was totally following what you laid out there, but I think this would make it clear that, let's say there's one predicate crime, an aggravated assault, and you charge 1615 for A, B, and C. This would make it clear that they can only be sentenced for one aggravated assault that is the predicate crime for 3 different gang crimes, but this makes it clear that the 3 gang crimes that are put on top of that one aggravated assault cannot merge. They would have to be sentenced separately, and they could all be run consecutively, if that's what you were asking.
Thank you. Number 18, is that Leader Trammell?
Thank you, Mr. Chairman, and to my DA friend from the Coweta Circuit. Welcome. I wish you were here the other day. I was talking about the burden of proof in the Coweta Circuit on a different bill. It could have been helpful to me. But I want to step back from the bill a second and just ask about your experience as a prosecutor. And how many gang prosecutions do you do a year in the Coweta Circuit, you think?
We looked at the numbers not long ago, and I want to say we looked at it over a 3-year clip. So over the last 3 years, we've had well over 100. And most of ours are occurring in Troup County. I think the second most are in Coweta. Third, I think, is comparable in Meriwether and Carroll counties. And frankly, a lot of that, in my view, is a consequence of LaGrange Police Department is the one law enforcement agency in the circuit that has dedicated gang investigators. But, for a circuit that's got 300-something thousand people, I would confidently say, we're doing, 20 to 30 at least a year, at least. Yeah.
Okay, and of that number that you're talking about, how many times did you run into problems prosecuting those cases because you didn't have the tools under the present law?
I guess by definition, we're only going forward on the cases that we can prove beyond a reasonable doubt under the current law. So,
So I don't want to put words in your mouth.
Yeah.
But I don't generally have a district attorney answering questions either.
Go for
it. So I think what you're saying is 0 of the number that you talked about of the cases in the Coweta Circuit. That there are 0 cases that you were not able to move forward with the prosecution because of a lack of tools under the present law.
I don't think that's accurate. I could give you an example. For example, we've unfortunately had a lot of juveniles that'll commit an aggravated assault. And if the victim of that crime dies as a result of being shot, we would get exclusive jurisdiction for that as a murder. If they survive, then it's just an aggravated assault, and we have to go through a transfer process out of juvenile court instead of having exclusive jurisdiction. So I think there are cases where, the law as it is, and maybe that process is totally appropriate, but I think it's unfortunately easier for us to move forward if, for example, a juvenile commits a murder as a gang crime than if the victim survives.
So if I could ask one
Yes,
final question. So I just want to understand, help me find the person that is falling through the cracks and escaping culpability under the present law that this bill addresses.
I'm much more well versed in the original version of the bill. I've read this one as quickly as I can here today, but I think it makes sense to add to the definition of criminal street gang activity what has been added here. For example, felony obstruction. If you're asking my opinion, I would say misdemeanor obstruction should not be a predicate for a gang crime because that's more of a a passive act of resisting or obstructing arrest, but gang members operate in violent terms. Like, that is their currency. And if a gang member obstructs law enforcement such that they have offered violence to a law enforcement officer, I think there could easily be a case to be made that they were doing that to increase their status within a gang or to maintain their status within a gang. So I think that this bill, using that example, felony obstruction, I think is a very valuable tool. Gang members act towards law enforcement to get street credit. They call it stain. And I think it's important for us to be able to respond to that with a gang charge when there is a nexus between that violent obstruction and the street gang. So that's an example of, I think that would be valuable.
All right. So what we'll do is, I see we have some who are seeking to ask questions again. What maybe we'll do is just to move things along. I see Ms. Sherry Boston is here, DA of DeKalb County. Would you be willing to come forward, Ms. Boston, if you'd like to come to the table here and provide any testimony, and then we will move on to other witnesses who are here. Yes. Mr. Patello, it's good to see you today. Thank you so much for being here. Mr. Patello, would you like to come forward and be in the third chair? Any other elected prosecutors in the room? Okay. Thank you. Ms. Holmes is here as well from Cobb County. It's good to see you, Ms. Holmes. All right. So I'll go ahead and recognize you first, Ms. Boston. Provide any comments that you might like to make about the proposed legislation.
Thank you very much. And I literally just hopped off a plane from D.C. And so I understand there's been an amendment, and I have not had a chance to review it in its entirety. But I have had a chance to listen to my colleague and some of the questions and concerns that the committee has. And I think they are valid concerns that we need to consider, which are, what are the gaps that we're really looking at, and does this bill, as set forth, achieve those gaps? And if I could answer, speaking on behalf of DeKalb, I think what you're going to find, we have 49 DAs in the state, and everyone has taken a firm stance on addressing gang violence in their local communities and with their law enforcement agencies in their communities, and every place is different. I wouldn't know how to deal with cases in DA Cranford's jurisdiction any more than he would know how to deal with the gang cases in mine. And so I do think that the penalties and the punishments and the law as it exists right now does allow us to actively pursue criminal street gangs, as well as pursue very lengthy and harsh penalties within the criminal justice system. I do have some legitimate concerns about how this type of bill, at least as I saw it worded before, again, I have not had a chance to really dive deep into the new version, tends, in my opinion, to net juveniles. And I know that my colleague brought up that very example of a juvenile that commits an aggravated assault with a firearm where there's a death would automatically go to Superior Court as an SB 440. But if there was no death, it would be an aggravated assault, which by its terms would leave it at this point technically within juvenile court. And I think that's a legitimate example, but I think it also points to the circumstance that much of this legislation potentially will net and bring more juveniles into the adult system, which I think we have to be extremely cautious and careful about when we are looking at the ways that we are automatically perhaps shoveling folks into the adult system. And so I would encourage the committee to look very carefully at, when we're building out these types of laws, what we're doing. And also the fact that, again, if we have juveniles right now that are committing certain crimes, we have the ability to prosecute them in adult court where the circumstances are appropriate.
So, Ms. Boston, I'm sorry to interrupt you, but the substitute, I understand you haven't had a chance to review it
Correct.
yet. The substitute does not include original jurisdiction in Superior Court.
Right.
So, is it your position then that you support that part of the substitute, or are you saying that, say, in your example, the aggravated assault by a 13-year-old should have original jurisdiction?
No, I do not believe that should have original jurisdiction.
All right. There are, maybe what we'll do is we'll hear from all of our prosecutors and then allow any questions to be put forward. So, sir, would you like to provide comment?
Sure, thank you.
Yes, sir.
Darius Patillo, I'm the elected DA in Henry County, Georgia. I've been a prosecutor now for about 17 years. This is my 4th year as the elected DA in Henry County. But prior to that, I was an assistant DA prior to Ms. Boston's tenure, and I prosecuted all major felonies over there. I was also the deputy chief over the juvenile court division in DeKalb County, one of the largest circuits in the state. So I have a lot of experience working with juveniles. I have a lot of experience working with prosecuting gang members. I started the first ever gang and homicide division unit, special unit in Henry County upon my election. So this was a bill that was of particular interest. I don't know why the mic is not working now that I have it, but this was a bill that was of particular interest to me when I first saw it. I did get kind of blindsided by it, but I'm aware of it. I am satisfied that some of my major concerns have been addressed, one of which making it a death penalty qualifier. That has, to my understanding, been addressed. I know we just got the amended substitute today. Juveniles being tried as adults, I didn't think that was necessary. Looking at the original bill, I don't see how it makes Georgians safer. I think that the laws we have on the books already address these issues.
So Matt was just telling me, if you back up a little bit from
Sure.
the mic, I don't think we'll have the popping
Okay.
as much.
Okay.
And also, if we could, if it's all right, sir, and to all witnesses in the room, if we could maybe really speak to the substitute that's before us at this point.
Okay.
I think that would, we have many witnesses and time's limited today. I think that would be a helpful
That's right.
use of time.
Thank you. And as I
Yes, sir.
stated, I am satisfied with the fact that the death penalty qualifier is no longer in the bill. If that's true, I haven't had a chance to read the entire bill, as well as the provision that makes the Gang Act an SB 440 type of crime that gives the Superior Court original jurisdiction. If those things have been addressed, I am satisfied with those changes. I think those are good changes, and I am very pleased to hear that that's the case, if that is in fact the case, given that I haven't had a chance to read the full bill.
Yes, sir. All right. Ms. Holmes, would you like to add anything? If you'd like to go to the podium, I'll hit the mic there.
Good afternoon, everyone. Joyette Holmes, District Attorney in Cobb County. I am likewise satisfied with those changes that were made. Those were the critical pieces for me. As DA Cranford said, the only issue that's remaining, from what I've been able to read since getting the substitution, is the venue issue. I share in those concerns, but I won't repeat them all, and that he did present those to you already. Thank you.
Thank you. For anyone that's come in, that's at the top of page 9 in the substitute, 279 to 283. All right, any questions for the elected prosecutors who are before us? Representative Reeves.
I forgot to push a button. I know I'm about to present here in a second, but there's been a lot of discussions that have gone on over the weekend, and I know that it's frustrating. We've just finished subs this morning, and so we're doing the best we can. This is how it works down here, especially this time of year. But the juvenile portions have been taken out of the SB 440 extensions have been removed. And so, frankly, unless somebody has concern with the 561 provisions that are put in, it would be really helpful to use our time to not talk about the SB 440 offenses because they're not in the bill anymore. So
That's new information.
I know, that's why I said I know that, but moving forward. So.
All right, Whip Bodie.
Thank you all for being here. I just want to kind of direct your attention. I know this was actually in the bill before, so this is not going to be anything new. Section 5, lines 182 through 187. As being elected DAs, it seems like to me lines 182 through 187, we're basically going to create a new crime for any individual that is deemed to try to maintain their status or position in a street gang, an individual with the intent to try to increase his or her status or position in a gang. My question to you, you are all duly elected and some great prosecutors on your own right, and you all try cases. How can you prove this? This seems very, very difficult to prove at the very least.
I'm glad you brought that up, because that was something else I wanted to address with this committee. The current state of the law is under 1615-4B. It is a violation for a person to commit a predicate crime if they're committing that crime to either obtain membership in the gang, increase membership, or maintain membership in the gang. So we're currently charging it in what we call the alternative. In one count, we can allege that they did it to, for example, maintain and increase. And the law allows us to only have to prove one or the other. Because we could do one count for maintain, one count for increase, one count for even obtain membership. But because it's all in one provision, you can only be sentenced for one violation of that gang act. I think, the effect of this bill would be to split up obtaining membership, maintaining membership, and increasing membership to 3 separate crimes that could be sentenced separately. In my opinion, I'm opposed to that change, primarily for the practical reason that you kind of alluded to. When using a gang expert, we can prove, and in my circuit, we have proven beyond a reasonable doubt, that a person committed a crime to either maintain or increase their status within a gang. Proving, exactly which one of those can be tricky or difficult, unless you've got smoking gun evidence like text messages, which happens, frankly. So I think as a practical matter, the current state of the law is very helpful, because it doesn't put the state in the position of going in front of a jury and having to say, well, you can find them guilty of obtaining membership or maintaining status, but not both. That can get kind of tricky. And I think most gang crimes, in my experience, are prosecutable under subsection A as being to the benefit of the gang, and prosecutable under B for, how it affects the member who committed the crime. Each of those carries 20 years in prison, potentially, on top of whatever the predicate crime is. So if you have an aggravated assault, you could get 20 years on that, then you could get another 20 years on subsection A, and then you could get another 20 years on the current version of subsection B. And at that point, you're playing with 60 years of punishment range, and that's substantial, obviously. And I think part of the purpose of the Gang Act is enhanced punishment, and I think there is a lot of value to that. But I think the current state of the bill gets us there, in my opinion.
All right, Representative McLaurin.
Thank you, Mr. Chairman. Thanks for coming back. Appreciate all you being here and your testimony. And Dia Cranfer, I especially appreciate the comments you just made about how some of these granular distinctions, I think, might be maybe even harder to prove up if you don't have the or, and also the fact that we're criminalizing what effectively could be the same conduct twice. We may have already discussed this a little bit, but line 249 of the sub provides that any crime committed in 1615-4 can't merge anymore. And so one thing I wanted to be clear on, so let's say an elected DA or your office makes a decision to charge up, let's say, obtaining and maintaining and increasing. Ordinarily, under the normal or the current state of the law, is it not true the judge has the authority to merge those offenses, or is that not how sentencing works currently? Like if you get convicted of all three, let's say convicted of two, can the judge say, well, I'm actually going to merge these two in terms of the sentencing recommendation and run the, but you said they can already run consecutively, right?
Yeah, so if it's charged, if there are two charges both alleging subsection B, the current state of the law, then those would have to merge.
They would have to merge.
But if a person gets convicted of subsection A and subsection B, those are separate crimes. And,
Okay.
and now they can be sentenced concurrently, but they would not merge. And I think, I didn't pull the case law before coming here, but I think that is the current state of the appellate law that a conviction under A and B would not merge. This is just codifying the way the law is being interpreted, which I think is a good idea.
I see. Okay. So
I'm sorry.
Yeah, no, please, Mr. Chair.
If I could ask a follow-up to that. So your understanding of the current state of the law is that the offenses cannot be merged, but they could be sentenced concurrently.
Yes.
Okay.
Correct.
All right.
And thank you, Mr.
Yep.
Chairman. Does the the adding of this merger language in 249, in you all's opinion, would that change the way sentencing can be conducted, or it's purely a codification of case law?
My understanding it is a codification of the current state of the law.
I would concur on that.
Okay, so then, if I may, Mr. Chairman, the main effect, the main increase or change in sentencing exposure affected by the bill in this code section would be the addition of the enumerated subsection that would add the new crime for maintaining versus increasing. Is that right?
My understanding is the only way this bill affects sentencing is by splitting up the current version of subsection B into 3 offenses.
Okay, and one final question, if I may, is, thank you, Mr. Chairman. Is there really a policy justification that you're aware of for separating, and we've talked about whether you can prove up a case in front of a jury, but is there a policy justification you're aware of for separating the criminalization of maintaining status versus increasing status in a gang?
I'm not aware.
Okay, thank you.
There may be, but I'm not.
I appreciate it. Thank you.
All right.
Representative Kendrick? Or is that Representative Setzler? Who's 27? Okay. Okay. Yes, ma'am. All right. I want to thank all of our elected DAs for being present today and being willing to provide comment. What we'll now do is we will invite up the sponsor, the governor's floor leader, as well as Director Reynolds of the GBI and Mr. Mike Carlson of the GBI. If you all would like to come forward. Oh, yeah, please. Thank you. Director, hi.
Pardon my dress today. I'm sorry.
You're in the field today?
I actually just came in straight from Rome. We had a death in the family. My father.
I'm sorry. Very sorry.
I was up there all weekend. This is the only clothes I had in the vehicle. So.
Never feel like you need to wear a tie to be here to present a bill. I appreciate you saying that, though. All right. We'll recognize Representative Reeves.
Thank you, Mr. Chairman and members of the committee, and apologize that I was. What did we cover before? When I came in, we were talking about the venue jurisdiction part of the bill with the Coweta District Attorney up here. What did we talk about before that?
Other than that, we just introduced the substitute and discussed an overview of the changes, which are really just involve sections 1, 2, and 3 of the substitute.
Okay, so you have you walked through the juvenile portions of this?
No, sir, not extensively. We did also hear from the Department of Juvenile Justice with some proposed changes to the language in section 3, which I can detail for you if you want.
Okay, so for everybody's information, and again, apologize the way this works, and we're doing things at the last minute and doing the best that we can. And when we come in on a Monday, as the chair is aware, we've been discussing this matter all weekend, and I've also been working with many others on this weekend. And we get in here today and we get our sub ready. And so, unfortunately, time is not a benefit that I wish that we had to be able to have everybody kind of with advance notice of how things are looking when we're coming in here for a hearing. But the juvenile component, obviously the original version of the bill as it appeared, added certain gang offenses that were particularly dedicated or focused on crimes of violence to the SB 440 offenses where the Superior Court has original exclusive jurisdiction. And that's a discussion that has been going on for some time, and we obviously recognize and understand the competing public policies in tough gang enforcement, and also recognizing what we know about science and juveniles, and how juveniles, how we aim and try to treat juveniles. I will say that I do believe that there are some instances where, especially with cases involving firearms, where there are instances that it is my position and the position of the governor's office that that there are some times where that treatment of bringing a accused directly to Superior Court is appropriate. But we also understand the will of the body and the committee and the competing public policies. And so we worked with, as the chair is aware, we worked with a lot of some of the groups that have juvenile advocacy interests at heart in moving away from 15-11-560 and moving into 15-11-561 and adding the criminal street gang evidence which is found in line 68, as when a juvenile court judge, when a DA can, if they do not have the right to bring someone directly into Superior Court, then they can file a petition on certain crimes. And it depends on the crime and it depends on the age, whether 13 or 14 or 15 or 16. And what the change that we have arrived at is to add evidence of gang participation as one of the factors that a juvenile court judge may consider in deciding whether or not to allow the juvenile to be tried in Superior Court as an adult. And it is a substantial departure from where the bill originally appeared, and I want the committee to be aware of that. And to address the other issue that's been removed, the death penalty portion, the governor's office very strongly believes. I understand the sub, and I understand the will of the committee, and I understand how this works, and I do believe that there is a worthy discussion about criminal street gang murder, and that it's the ability for that to be used as a qualifier for death. I do believe that is a conversation and discussion that is worthy of this body having, and that's something that I very well may proceed with in a separate measure or at a future time. But I understand that it is not in this substitute, but I do want to make clear that the governor's office does feel strongly that there are instances where a gang-involved murder should be a qualifier as one of the aggravating factors to argue for the state to pursue a death case. That being said, the other issue of contention that I heard when I walked in, and I've also heard, is dealing with the venue issue. And I just want to say to the committee and to everybody behind me that we're here to listen on that. I've obviously gathered some of the testimony on that, and this is not an attempt to divest anybody's jurisdiction or anything like that. We are hoping to be able to figure out the best way to address that issue, and so that's something that will be years on. What I really want to do now, Mr. Chairman, is just have Mr. Carlson walk through the bill, which I'm going to fast forward to Section 4.
If it's all right, since we were just discussing venue, it's also been a real topic of conversation. Mr.
Sure.
Carlson, could you comment on maybe so if you have a circumstance now where, say, there's criminal offenses being committed in multiple venues, what are the options currently for prosecutors, or how might that work? And then if you need any clarity as to some of the concerns that were raised as to this provision, I can outline that for you. But then what are your thoughts or comments about what's been said about it?
And thank you, Mr. Chairman, and thanks to the committee for allowing us to be heard here today. Again, this comes down ultimately to the sort of issue that the people before me will have to resolve, and that is policy. Currently, the racketeering statute has an identical venue provision. That is where this comes from. So the question is whether criminal street gangs, which exist in such a greater magnitude in terms of their number and criminality and victimization would be subject to the same venue provisions that a three-person racketeering enterprise might be. So that's the policy decision that's here before us today. Whether or not, if we have individuals, and there are pending indictments like this in this state, like Larry Hoover, who operated the Gangster Disciples, which by 2009, according to federal authorities, numbered up to 50,000, all across the country, including here in Georgia, can operate that organization from a location in prison, as we have pending indictments in this state right now. Gang bosses are operating from prison, multiple county gang activity, whether it serves the best interests of the people of this state, just like if this was a Cosa Nostra case, a mafia case, just like if we were talking about, again, a racketeering enterprise of county employees that might stretch into one county or another, whether it can and should, in some cases, be brought in one of the multiple counties where all of that criminal activity is being conducted.
I think
that's the policy decision here, and that's left to.
I think the concern, Mr. Carlson, was that let's say that there were two venues, Venue A and Venue B, where criminal street gang charges might be treated very differently, okay, as far as recommendations from prosecutors or sentencing by trial courts. And the concern might be that one venue would be able to potentially resolve the entire case for criminal activity that occurred elsewhere. And because of principles of double jeopardy and of trying the entire matter for the same transaction, that this might actually have the contrary impact of what was intended. I think that's the concern that's been raised. That's why I was asking, with respect to that concern, can you address that?
Sure.
Yeah.
It seems to be there are several different issues there you brought up. One is, let's say, inconsistency, and of course, that's been pointed out by commentators on criminal justice over the years. There can be inconsistency from one ADA to another within an office. So that's a bit of a consideration that we're never going to completely get out of the criminal justice system. The next question is, do we currently have a situation where state and federal, or county by county, or state and state, or let's say jurisdiction and jurisdiction here in Georgia, where different offices and different jurisdictions are fighting with each other over who gets to indict and try the huge gang racketeering case first? I spoke with Jimmy Calloway, GGIA, Georgia Gang Investigators Association president today. He says he's not familiar with that ever happening. The cases like that are pending now in this state is where the DAs have all cooperated together and the law enforcement agencies have cooperated together, just like we do with deconfliction agreements with the federal government. So again, that is a academic consideration, but not one that seems to have, or that anyone I've spoken with has any experience with currently.
So I only ask because of questions that have been brought to me, and it's my practice not to try to come up with extreme hypotheticals when we're discussing bills, but I do think we need to thoroughly, of course, consider the language. And a hypothetical that was brought to me is a criminal gang that maybe is centered in the Metro Atlanta area. Members of the gang go to South Georgia and in multiple judicial circuits commit armed robberies, thefts, car break-ins. Is it your understanding that this venue provision would allow that offense to be prosecuted in the Metro Atlanta area, despite the fact that those armed robberies and thefts occurred in faraway judicial circuits in South Georgia?
It could be, and right now it could be indicted like that under the racketeering laws. And I don't know if before I arrived here today if there was any motion to incorporate into this bill striking that RICO provision. Was there?
No, sir. We're just trying to understand the
It-
language that's been proposed, and the RICO statute is not before us at this time.
Understood.
So this is an opportunity for us today to have, I think, a constructive discussion and answer certain questions. And if it's your proposal that other statutes need to be cleared up, then I think we'd be interested in hearing that as well.
Just the opposite. It works perfectly well, and it's been upheld over RICO. I've been there for those cases being argued under our racketeering statute.
Very good.
That's
All right,
exactly
we'll go
why-
back to Representative Reeves to go ahead and present the remainder of the bill.
Okay, so looking at Section 4, which is starts on page 3, and what this does is it redefines, if you go to line 128, it redefines criminal gang activity to provide a new list of offenses that would be effective as of July 1st of this year. And if you move on, even though everything is underlined, it's only underlined because it's being restated. If you look at lines 136 through 139, these are new offenses that have been added to the Criminal Street Gang Act. And then if you look at line 159 through 162, it adds another. So the latter, 159 through 162, is felony obstruction. And at the 136 to 139 is it adds.
Actually, I'm sorry. I think if I could correct you there, it doesn't add. Several of these offenses are already in statute, but I believe child molestation, aggravated child molestation, there's a few selected additions.
Actually, it's yes, and then child molestation and aggravated child molestation and enticing a child for indecent purposes is what has been added. And there's reasons that these have been added, and I am going to allow, I would prefer for Mr. Carlson to.
Let's just walk through the bill first, please.
Okay, so it adds those. Moving ahead to Section 5, there is this was discussed in the prior testimony, there is the separation of maintaining and increasing status. And that's something that I would like to discuss with Mr. Carlson at the appropriate time. The non-merger clause in line 249, which has also been discussed. Section 6 of the bill on page 8 works in our efforts to allow our local governments to establish nuisances and in specifically relating to criminal street gang property. Section 7, obviously the first portion of this has been discussed significantly, and that's a work in progress right now. The section after this, which would be proposed as Section 16, 15, 13, would be new to Georgia law, and this provision would allow for injunctive relief that a superior court judge could make certain equitable and injunctive rulings as it relates to various aspects of gangs. Again, that's something that Mr. Carlson has a lot of expertise on to testify to. Section 8 is a portion that relates to the changes that took place in Sections 1, 2, and 3 with the DJJ. So I think that's already been discussed, and so we can come back to that. And then Section 9 adds to the sex offender registration list. And I'm sorry, my notes are on my version of the bill, which is not the sub. So, and the new acts that have been added to the sex offender registration is on line 385. This would add number 4, burglary with intent to commit a sexual offense. And then it would also add on 399, 400, and 401, keeping a place of prostitution, pimping, and pandering would be added. And then 404 through 406, and these are obviously only felony crimes. There's another clause in Title 42, which you do not see in this bill, but there's another clause that says that misdemeanor offenses are not. So it would only be the felony version of keeping a place of prostitution, pimping, or pandering that would put you on the sex offender registry. And the final one is in lines 415 and 417, any conduct which involves violation of the Criminal Street Gang Act and which involves an underlying sexual offense or the intent to commit a sexual offense. And Mr. Carlson could talk about specific reasons as to why that is on here and what we are seeing in gang cases.
All right, so we'll open it up now for questions for the sponsor, Director Reynolds, or Mr. Carlson. All right. Representative Bodie.
Yes. I do have a question.
Pete.
I do have a question in regards to, on page 12, the new offense of burglary with the intent to commit a sexual offense. Now, Mr. Chair, in this particular situation, I've been practicing criminal defense law now for a while. I have never seen that charge indicted, burglary with the intent to commit sexual offense. I have seen it indicted as a separate offense of burglary and whatever the sexual offense was, either rape, child molestation, aggravated sexual battery, or aggravated sexual, some type of sexual offense. So right now, I don't even know if this is a true crime or not. And so I'm just very concerned why this is in the statute and why we're adding it.
All right, Mr. Carlson, if I could maybe join in the whip's questions, I think the question is, how is that offense identified if there is no specified burglary charge, if there's not a burglary with intent to commit a sexual offense, say, compared to aggravated assault with intent to commit a rape or something like that? Yeah, can you answer that?
May I?
Thank you.
And again, in answer to the previous question, again, I think if it comes to that venue provision, the DAs will cooperate with each other the same way do with federal authorities or do on RICO cases. And if there was, again, we just want to make sure my answer is clear on that. On this, there's actually a case where the defendant was charged with burglary with the intent to commit rape, was placed on the sex offender registry, and then had to be removed. And this individual had come into a residence, and again, exactly the sort of situation that folks would be most concerned about. With all the evidence demonstrated, he had desires to commit sexual assault on this lady, and was charged and convicted of burglary with the intent to commit, I believe it was rape. It's been years, and was subsequently removed from the sex offender registry, and then from prison, even after being removed, sued the judge and the prosecutor on the case, and the AG was then had to handle that case. So the underlying conduct involved was of a nature that would have led to a sexual offense had things not been interrupted. So that's part of the motivation here. So if someone breaks into a house in the middle of the night looking to sexually assault another individual, should that person, once convicted of that offense, either through a guilty plea or a jury trial, be placed upon the registry simply because of happenstance they were not able to consummate the criminal sexual act? Again, policy decision here. Obviously, the feeling is yes, and it does make sense, and there is a case that demonstrates this vividly that I personally am familiar with. And incidentally, we're constantly doing that when it comes to the sex offender registry. We receive at GBI, at Legal Services, packets, and of course a lot of what that requires us to do is review the laws of other states or even federal laws to see how they line up with Georgia. Does this represent a sexual offense? Does this represent the type of offense that should or shouldn't go on the registry? So a lot of work goes into that, and that would obviously be paralleled here with this provision.
So I guess if I understand what you're saying, then it would be the channel that would receive these types of charges would have to be reviewed for the indictment to determine if the underlying felony that was the intent element of the burglary was a sexual offense.
There would not only be a review, that would have to be part of the conviction. Here is my understanding of the statute is that, or the proposal is that, again, it would be burglary rather than with the intent to commit a theft, with the intent to commit rape or another sexual offense. Child molestation could be.
So is there not a criminal attempt? I'm just asking, is there a criminal attempt condition for sex offenders? So say criminal attempt to commit rape. Does that not capture, is that not a sex offender registry offense?
Right, but remember, yes, but we're bound to the charge as it comes through. So if the conviction was for burglary with the intent to commit rape, as it stands, which would carry a heavier sentence than an attempt in many circumstances, that would not be an offense that could make it onto the registry.
Okay, and I understand.
So it's essentially a loophole that this is seeking.
That the statute is generally updated, kind of altogether, but fair to say that specifically, that's not really connected to the underlying gang issue. It's just since we're in the sex offender registration statute, you're proposing those updates as well.
Well, yes, and some of these I was not as involved in along the way, so I'm familiar, but perhaps not as knowledgeable with some of them.
All right, Representative Setzler.
Thank you, Mr. Chairman. To the governor's floor leader and GBI reps, I wanted to wade into the question that the chairman was addressing on lines 385 through 386. Maybe just a suggestion and get your thoughts. Yeah, as a members committee, I've tried to, over the years, parse these kinds of issues where there's an offense, but yet there's some qualifying conditions that a subset of these offenses, if certain qualifying conditions exist, then it's able to bring a different sort of remedy or penalty. Would it make sense, I'm asking the floor leader or parenthetically the chairman, would it make sense to create a new criminal offense, quote, burglary with the intent to commit a sexual offense, that has its own definition and elements so that it would fit comfortably in here? So we're not trying to create burglary with a subset of conditions, but we have some new thing. Would that not be a technique to accomplish your goal?
I understand your question, and it very well may be. That's not something that I have thought about yet or looked at in regards to this, but if I recall, the burglary is either you enter to commit a theft or to commit a felony or any other felony offense, and so it could be a range of a whole lot of things. Now, if we start to articulate one type of thing, such as a sexual offense, then then does it cause us the need to also articulate everything else? And I don't know, sitting here right now and thinking, as what's coming through my mind, I don't know the answer to that. It could be one of those things that makes things more complicated.
All right. Oh, do you have a follow-up?
No, I just wanted to thank the gentleman, Mr. Chairman, on as we've restated this new definition of criminal street gang activity by adding child molestation, aggravated child molestation, enticing a child for indecent purpose, adding those as well as the felony obstruction. I do think those are important additions, Mr. Chairman. I know when you think about, as I've talked to folks over the last month about the kinds of things that gangs use to kind of wreak havoc or to assert their power, I think both of these are important additions that I would commend to the committee.
Mr. Carlson, it was said a moment ago that the sex offender conditions on this list must be felonies in order for sex offender treatment to apply. Is that correct?
Yes, although that's changed some with this here, I believe. Again, I'm not as familiar with all the ins and outs of what's been added here, but I think some of the pimping offenses.
Well, this is as introduced. Mr. Reeves, didn't you say that it's not included in the bill, but elsewhere in the code, it must be a felony offense?
Yes, I believe last year we, if I recall, Representative Anolowitz's bill created felony provisions for pimping and pandering and keeping a place of prostitution, and I do not believe that there was a component with that which created the sex offender registration on those felonies. And so this I believe it's a complement to what happened last year.
All right.
So they would have to go in as the felony grade, is my understanding.
Yes, it's not possible to be put on the sex offender registration if you're convicted of a misdemeanor. It's not possible.
And so that is important context to give, particularly to what's being proposed here in lines 415 to 417. It would have to be a felony sexual offense.
That's right. And Mr. Carlson can talk about there's an entire reality of sexing into gangs, and I think that it is important to understand the context of that. Do you mind if he talks very briefly about that concept?
Sure. No, please go ahead.
If there's a particular question, maybe that would speed
Okay.
things along.
All right. All right.
I think because the gang statute is itself a felony, is all a felony provision, then they'd have to be convicted of a felony to go in under 415 to 417.
All right, very good. Any other questions? All right. Okay. So I want to thank Director Reynolds. Director Reynolds, maybe final word, anything you want to add to what's been said today?
Well, not being a policy-driven, not being in a policy-driven job as director of the GBI, there's a reason I bring my lawyer with me, Mr. Chairman. So thank you for your time. And I do want to mention, too, there's a lot of friends behind me. I was a former district attorney of Cobb County. I have a great deal of respect for the folks here. I have a great deal of respect for, on occasion, when we disagree, to listen to them. Thank you for giving us that opportunity to be heard, as well as my friends who are sitting behind me, and I'm convinced this committee will do the right thing in the end, so thank you.
Well, I know I want to say on behalf of the committee, I think it's fine to say we're very grateful to you for your service and your leadership, and appreciate you being here today. So, all right. So,
May
yes,
I
sir,
have,
go ahead.
Yeah, and again, we're not voting on this today, right?
So maybe what we'll do is hear testimony and then make a determination as to what's next. If certainly if any member wants to be excused to kind of huddle in the hall to discuss language, I think that that's always welcome. So
sure. And I mean, what I would prefer is to go back and look at some of what's been discussed in here, and will continue to be discussed. And is your intention to try to make those changes now or no?
Crossover is next week, so we are working very hard to perfect legislation as quickly as we can. But I am sensitive to the sponsor's concerns, and it is his bill. So maybe what we'll do is we have a few witnesses signed up today, and so what I'd ask you to do, actually, if you all would like to remain at the table, you're welcome to. If you want to address any of the comments, or if you'd like to step aside, either's fine with me. And we'll just ask, first on the list is Melissa Carter. If you'd like to come forward to the podium, please. Thank you. Please go ahead.
Thank you. Good afternoon, Mr. Chairman and members of the committee. I'll keep my remarks brief. I know you have a lot ahead of you. And also constrained to just sections 1 and 8 of the bill. The center that I run at Emory, the Barton Child Law and Policy Center, does a number of things in this juvenile law space, including provision of legal services to delinquent children, and also some appellate representation to our youthful offenders, those class of offenders who are serving time in prison as a result of our SB 440 offenses. And of course, then you see us down here doing our policy and legislative work, and I've enjoyed working with all of you on that. I really just I'm glad to be here in this place with the substitute to just use this time to really thank you for the significant departure from the original proposal on House Bill 994. I believe we're in a bit of a 180-degree place with respect to those juvenile provisions, and more so than just changing and pivoting around what the policy is. I think what we ended up here with actually in this substitute actually puts us in a really positive and strong direction in terms of doing what will be effective for youth. We know that kids require individualized assessment and access to evidence-based programs and interventions, and I appreciate Commissioner Oliver and his team for committing to making those available and casting the vision around kids and the work that they'll do through the Department of Juvenile Justice. So with that, I just want to say, put my name kind of behind the changes that have been made there in Section 1 and Section 8. Thank you to the sponsor and to the chairman and to all of the members who've worked with us and heard our concerns and have been willing to really confront and look directly in the face the body of research that tells us about how kids can best be managed with respect to some of their problematic and criminal behavior.
Thank you very much. Any questions from Ms. Carter? Whit Bodie.
Ms. Carter, I know this does not involve the bill per se, but I know you work with the Barton Center. You do an excellent job. This may be a question for you or Gacto. But are you familiar with the definition of gangs at the national level, having a standard from the National Institute of Justice on how we actually identify gang members, from the tattoos, from a reliable source that individuals actually in the gang? That's a little bit more tighter than what we have in current code. Can you maybe walk me through that a little bit if you have any knowledge on it?
A bit, though I think I probably would be best served to defer to the criminal defense bar representatives who are here, even the prosecutors who are here. What we've looked at, I know less about the national standards. What we have looked at are sort of across 50 states, how Georgia sits with respect to some of those definitional features on the criminal gang level. And so we always know, of course, that there's some associational component. There's usually a number of people who have to be joined, and then some characteristic that affiliates them. And so in many ways, what we found is that our laws are not necessarily out of line, although again, I'm not sure that I am the best expert to speak to that directly.
Thank you so much.
Thank you.
Ms. Carter, Professor Carter, the language that was proposed by Commissioner Oliver's office a moment ago, is that acceptable?
Oh, 100%. Yeah,
Right.
very much we're on the 100% in agreement with the concept. The wording was really just the finesse piece. So absolutely.
Thank you.
I would go back, I'm sorry, Whit Bodie, if I could just kind of come back for that. I think what we do get concerned about, of course, are the features around criminal gang activity in the context in which I am more of an expert with kids.
Yes.
The idea of kids and doing the sort of seeking the belonging and the identity, and therefore being joined in these ways and performing, demonstrating, behaving in ways that would then trip over that definition. I think that's the piece, again, why putting the interventions in the juvenile court make a lot more sense, because that's really where we have the expertise and the familiarity to understand what that looks like in terms of development, as opposed to an intention around criminality.
And so it is true when we have youngsters that are in these neighborhoods, older family members, friends, they're wannabes. So they're not actually gang members. So you would probably agree that we need to have more defining mechanisms to actually identify them through their actions and through someone actually saying, yeah, this person actually is in the gang and they're just not a wannabe. Would that be a correct assumption?
I think so. In this context, I think just like any other, this is the challenge, I think, of our criminal code. And this is the design of it, right? That these offense categories can be pretty inclusive. And what we really actually know are the actors themselves represent a range of intention and a range of responsibility and involvement in any crime. So that the use of these categories, these offense categories, isn't actually reflective of the culpability that we're trying to assign through our criminal laws and the punishment that's attached to it.
Thank you so much.
All right, thank you. Thank you
Thank you,
very
I
much.
appreciate it.
We'll call Marissa Dodson next up to testify. What we're going to do, I'll go ahead and give everyone a heads up. As soon as Ms. Dodson finishes with her testimony, we're going to take a little break. We've been going for over an hour and a half, and we'll take a little break, and then we'll come back in and finish the committee meeting for today. So thank you, Ms. Dodson. You can go ahead.
Thank you, Chairman and members of the committee. My name is Marissa Dodson. I'm the Public Policy Director at the Southern Center for Human Rights. I stand here to recognize the tremendous work that has been done on this bill from the version that was originally introduced, and want to commend the sponsor and the chairman in this committee for really hearing some of the concerns that had been raised and for making such a big change to the language. I have a few of the concerns that we have already been articulated today, but just so that for clarity, I would like to say that we continue to have some concerns with that sex offender language, the requirement that particularly those who have been convicted of this burglary with the intent to commit a sexual offense, that would be particularly problematic. We also have some concerns with the merger. I understand from the testimony today that there's some expectation that this language just codifies the case law on this. That has not been my experience, but happy to look into that a little bit further. And then the other issue that we have with regards after the sex offender registry, the merger language, and then there's one I'm missing.
The venue
Thank
language.
you so
Yep.
much, Chairman. The other concern that we have is venue. And as has been articulated by the prosecutors today, we think that there are some concerns with that language and would at least want to narrow the kind of offenses for which the expanded venue would apply. We would like you all to consider perhaps narrowing that to sex trafficking trafficking and kidnapping charges where we would have that kind of expansion of venue.
Okay, so you would be, you're saying that you have no objection to a limitation on that venue provision for kidnapping and sex trafficking, but that is outside of the criminal street gang context.
That's right. Well, I think if you would want to make it in this code section, that at least we would narrow it to that kind of behavior when those elements are present, that we would not open up venue shopping, if you will, for all of the offenses in the code section.
Okay. A few questions, if you don't mind. Representative Setzler.
Thank you, Mr. Chairman. Ms. Dobson, would you agree that if you had an offense that was essentially needed to be proved as burglary with intent to commit a sexual crime, you recognize, would you agree that the proving the element with intent to commit a sexual crime, that's not an easy thing to prove? Is it?
I would agree that there may be some challenges with proving that particular part of the crime. Yes, okay. Yes, Chairman.
So you recognize if that were, because that's a bar to clear. That's not an easy bar to clear. But if that were demonstrated, wouldn't you agree that a burglary that you were actually able to prove there was an intention to go in and commit a sexual crime? Wouldn't you agree that's a more severe crime, has a much more sort of dangerous criminal component to it than things that land people on the sex offender registry today?
I think that the concern that we have with the language is that it's broad and that it could be interpreted to include offenses that are not currently ones that are eligible for registry under the sex offender laws. I would say to you that if there is enough proof that the person was seeking to attempt a crime of a sexual nature, we have attempt statutes and charges that could capture that conduct as well as the burglary.
But as you know, criminal attempt is a step down from the crime itself, and it doesn't. This idea of creating burglary, which is an enhanced burglary, which is a very serious one because of this intent to commit a sexual crime element. Criminal intent sort of moves back down the other direction. It just seems if we're trying to create something that's a more intense crime of burglary, or it's a burglary with an additional element. I don't know that criminal attempt, which is a step down, kind of gets us in that direction. It would seem to me that consistent with other sex crimes, if you're trying to get an underlying criminality that's allows us to bring what we would hope to call justice. It seems like there's no means, if you can demonstrate that clear intent, to address that another way. What would be a way that you would suggest we address this if we wanted something that were a burglary, that you can prove up this intent to commit a sexual crime? What other mechanism would we have in law?
I would posture, not that I would support, kind of expanding the list of crimes for which people should register. I have my own views on whether or not sex offender registries actually keep us safe, and the more people we put on them, the argument is the less safe we are as a public. I would, though, suggest that we should at least be specific with regards to the conduct and the charge itself, that it would at least say burglary with the intent to rape, and that there wouldn't be this kind of broad stroke, any sexual offense. I'm concerned about vagueness under the Constitution and also pulling in conduct that wasn't contemplated as a registrable offense, if you will.
So someone commits burglary with intent to share illicit material. It seems almost absurd to think about that, right? But you believe that this committee would be well served if that was our policy intent, is to define the kind of sexual activity we're talking about a little more clearly. But you recognize the policy goal, okay?
Yes.
All right, with Bodie.
Thank you so much for being here, Ms. Dawson. I have a twofold question for you. One is what we discussed in Section 5, lines 182 through 187. One section dealing with the maintaining his or her status in the position of a street gang, and the other, the intent to increase his or her status in the street gang. Do you feel like this is necessary under current law and what you heard from the DAs that actually testify here today?
No, I do not think it's necessary. I think, as indicated by the testimony that we've heard, that all this is doing is disconnecting conduct that they are prosecuting now alternatively, and that to do this just creates additional crimes, and not that in a way that would not further public safety and make us new.
So I have another question for you. Currently, how we define street gangs in Georgia, I know we've had many conversations about this, and I know you've done a lot of work. The National Association of Justice, National Institution of Justice, give us more tightened language that have been used in other states to actually really identify hardcore gang members, such as tattoos and an affirmative testimony or a statement from another gang member saying, yes, he is in a gang member or she's in a gang member. Do you feel like if we're opening up the criminal code as far as gang, we should also reevaluate and look at how we define gang activity?
I absolutely agree with that. I also think that in light of the funding and resources that have been made available for the database, that's also something that we should consider. How do people get on the database? What's considered gang activity? And right now, I think that both the definitions in current law and in terms of how that database is being populated, I would suggest that the net is is cast much too broad and is capturing conduct that is not the kind of conduct that we think about when we traditionally think about violent
So we'll do
gang
one more
activity.
question.
Just one more
Yeah.
follow-up. You said something that I want to follow up with. In this Georgia, we know how you could possibly get on the gang database, but I have issues, or do you have issues on how you actually get off? If you have been convicted, done your time, stayed out of trouble, because there's really no way to get off the database.
So there's no provision in this bill as to a gang database, right? So
That's right.
we're a little outside of the issues in this bill, respectfully. So, all right. So what we'll do is we'll take a little break at this point in time, but the committee will come back in a little bit. We've been going for about an hour and 45 minutes, so we'll take a break now. Thank you. So there have been several proposed amendments that were made as part of this legislation. And Mr. Reeves, would you like to walk us through those, or would you like me to do it? What's your pleasure, Mr. Reeves?
Mr. Chairman, based on if the chair is willing to entertain a vote today, then what I would ask to do is looking at Section 7 and recognizing the inability to get consensus and agreement with our district attorneys on this. I would ask this committee to strike the first part, lines 280 through 283 at the proper time, which would then change line 284 from 1615.13 to 1615.12. I do not know if there are any other cross references, but what I would ask is for that to come out, and then for the bill to be voted on, the remainder of as is.
Okay, and the other provision that was included was on lines 85 to 87, removing A on line 85 all the way through gang on 87 and replacing with an evidence-based intervention program that has demonstrated efficacy in addressing factors that impact adolescent gang involvement. Is that right?
Yes, I do believe so.
All right, very good. So at this point in time, I'll entertain a, well, first, what we need to do is we need to receive, I'm happy to hear, is there a question, number 24? Yeah, go ahead, Representative Sainz. Oh, all right. All right, very good. Chairman Setzler.
Mr. Chairman, at appropriate time, I want to make a motion.
All right, we have a few other witnesses who are on the list. I'd ask Jill Travis to come forward. Yes, please.
I know the hour is late. I will be as quick as I can and have a few issues. With regard to section, I'm going to start at the back of the bill with respect to section 9 of the bill. Would ask the committee to consider taking out lines 385 to 386, the burglary with the intent to commit a sexual offense, as that is not a defined crime. The circumstance that Mr. Carlson told the committee about could have been charged as burglary and an attempted rape. And if the conviction was for an attempted rape, then the person would have been able to register. So we ask that those lines come out. The same kind of concern exists on lines 415 to 417, having to do with a sexual offense. And the sexual offense not being a defined term for this, and the possibility of including it in a misdemeanor. If the committee was willing to consider having the word felony before sexual offense, that would go a long ways into making that abundantly clear.
And I have no issue with that, Mr. Chairman.
All right, would you restate that amendment? Sorry,
I have no issue with the second amendment that she made.
Yeah, would you just repeat that for the committee members?
On lines 415 through 417, specifically at line 417, if you inserted the word felony before the word sexual offense in the two locations, that would be my request. Going back to the front of the bill now. By the way, we very much appreciate the work of the committee and the hard work of the subcommittee chairman over the weekend and making all the rest of the changes, so I'm not going to belabor that. We'd also, on page 5, at lines 159 to 162, the crime of criminal gang activity now includes the offense of felony obstruction, which can be very, you don't have to actually do violence to an officer to be charged with felony obstruction. It's words alone are sufficient for felony obstruction. And the fact that words alone are sufficient for felony obstructions, you have to offer to do violence. Officer, get your hands off me or I'm going to hit you. That could be enough for a felony obstruction.
So it'd be the words combined with the swinging motion.
You'd have to, I mean, or if you don't get your hands off me, I'm going to stab you, even if you don't even make a motion. There's a lot of stuff that falls into the category of obstruction as a felony because it can be words alone.
Okay.
So we ask that comes out. With respect to page 6, section 6, we would like to add the words, I'm sorry, I skipped a page. On page 5, page 6, section 5, the same concerns that the prosecutors expressed with regard to lines 182 to 187 and the current law, we would ask that you return the language as it appears on lines 180 to 181. And I'm not going to reiterate the concerns that have already been brought up about merger, but we'd also ask that be, basically that section be removed in its current state. With respect to section 6 specifically, this is the nuisance law, and I would just like the committee to consider borrowing language that it put into place last year. Looking specifically at line 255. And I would ask the committee to consider adding, when an indictment is returned by a grand jury alleging criminal gang activity, any person, then keeps the rest of it the same. The difference there is the way that the language is now at line 255 is you're just committing an act. It's no finding by any kind of legal body of a grand jury proceeding. And that was the language that you all specifically put into the law last year having to do with nuisances. That's all my concerns, Mr. Chairman.
Thank you very much, Ms. Travis. Representative Setzler.
Thank you, Mr. Chairman. Appreciate Ms. Travis's presentation on this. If again, I'm going to float a hypothetical.
So is the gentleman asking her a question?
I do.
Oh,
yes,
okay. Thank you.
Ms. Travis, if the committee were to perhaps hypothetically make the amendments you suggested throughout the bill, would GACTL be in support of passage of 994?
Yes, sir.
Okay. So
I mean, to the extent that I'm going to say it. I'm going to couch that. We don't love this policy, but we would love this bill a lot better. I don't think that all my members are going to say that we think that the gang law needs to be changed. There's a lot of law that RICO is involved and that it could be prosecuted in that manner. But I will say that I'm asking for the changes that I'm asking for, and the changes that you've already made are the things that my membership has asked for. Whether we love it and would say vote in favor of it, I can't speak to that specifically, but I can say that we can support it with more fervor than the way that it presently stands.
So I asked the question because I'm trying to get at. I think this governor is trying to get at a underlying gang statute that supports Georgians' safety and safe streets, but yet represents the justice interest that all of us would have. I think there's been a real back and forth, both in the committee and out of committee, trying to wrestle this policy. And I just wanted to know if, I think there's a real desire among our members of both parties, or certainly on my behalf, that this would be a bipartisan bill. I'm persuaded by much of what you said. I don't know that would support everything you're saying, but I just want to know if we give you all of that, is it something GACTL could say, you know what, in the spirit of moving forward, we think this is a good thing. We would support legislators getting behind the new 994.
I think, the bottom line, we presently think that the gang laws are the toughest in the country, and that there's certainly lots of ways that prosecutors have tools in their toolbox to prosecute criminal gang activity. So I'm not sure that we could say this is a necessary act. I do think that the juvenile code would be aided in the sense of being able to have gang type programming available in the system. So I think that that's a good change.
Mr. Chairman, can I ask one further question?
One last question.
Okay, to the question of the felony obstruction, I mean, clearly you can understand how obstructing or hindering law enforcement is part of perpetuating, protecting, and advancing a criminal street gang enterprise. If underlying behavior is severe enough to be a felony under our code, isn't felony and misdemeanor a pretty good dividing line for us to use to divide between, you know what, we're not going to use this as a predicate, i.e. misdemeanor behavior, but felony behavior, if the underlying behavior is serious enough to be a felony, isn't that a good dividing line for us if we're trying to wrestle with this issue of hindering and obstructing?
I agree that in certain crimes, the felony misdemeanor divide are very clear and very straightforward. But the problem with felony obstruction is that because you just have to offer to do violence, that's actually the language that's used in the code, you don't have to actually do the violence. So if there was perhaps a felony obstruction in the first degree, for example, that actually violence is committed against a police officer, actually some kind of damage is done, as opposed to the way we have it now, it's just offering to do the violence.
So you prefer a more serious felony, but is it not a more reasonable place for us to divide along felony, misdemeanor versus throwing any crime in there? Because there's discussion that perhaps misdemeanor obstruction could be included. I would ask the lady to consider that, and I appreciate the authors drawing the line at felony, because the underlying behavior in furtherance of the gang is very serious. By definition of it being limited to being felonies. Thank you, Mr. Chairman.
All right. Thank you very much, Ms. Travis. Marcus Coleman. Hello, sir.
Good afternoon. My name is Marcus Coleman, founder and former president for Reverend Al Sharpton's National Action Network, responsible for the acquisition of the Southeastern Regional Headquarters, founder and president of my family-birthed organization, Save Ourselves. Last two sessions, I was had the honor of coming before you guys, along with Abel Mabel Thomas, Senator Parrott, and successfully passed Senate Bill 1, known as CJ's Law, named after my cousin. So I appreciate everybody's help in these last two sessions. This is a dangerous piece of legislation. Before I begin, I would like to say I don't believe it was done in any deliberate manner, in any racist type manner. I do believe it was done to address that problem, to address the problem of violence. But I want it to be clear. You can be substitute House Bill 994 and also be anti-violence and anti-crime. If you stab me in my back, to quote a famous brother by Malcolm X, if you stab me in my back and take that knife out 3 inches, I still have a knife in my back. I say that because some people don't even want to realize the knife is there. The knife in that story to be this criminal justice system that we know has documented disparities as it relates to black, brown, and low-income communities. It's baffling that we have, and again, in the spirit of unity, because I understand this wasn't done deliberate, but it's baffling that we have legislation that basically is a new teen RICO law. Conspiracy laws that were meant, I heard someone mention it earlier during testifying, that was meant to capture, entrap the Cosa Nostra, but ended up working so well on low-level drug offenses and offenders that really aided to mass incarceration, prison industrial complex. And now what's puzzling also is the former governor of this state got kudos and awarded on both sides of the aisle, being a champion of criminal justice reform. That's what Georgia had become, the beacon of this nation for criminal justice reform. Now with this legislation, no matter how good the intent, we're getting ready to open the floodgates to then incarcerate more people, and those people being children. I think it reverses the productivity that many people like myself and others, along with the former governor, have done, and it strips Georgia of its beacon status. So we would, on behalf of the community, I'll close, there is a groundswell of organizations, I mean state and national, NAACP, SCLC, I can name Urban League, I can name them all, that we have a groundswell. Now, it was originally against the original piece of legislation, so of course we have to dissect the substitute, and I think it even might be a substitute to the substitute. But we would like for you guys to go back to the drawing board. We feel legislation on gang prevention coming out of the beacon of a state for criminal justice reform should be riddled with more preventative measures, in understanding that there are reasons why individuals are in gangs. The identification as it relates to gangs is going to entrap my 14-year-old son, is going to entrap black, brown, and also hirelings, the low-income Caucasians. It is going to entrap. So we would like to see more preventative measures. And I know you've been working hard, but it's the community's stance that you go back to the drawing board, scrap this, and come up with one that is more conducive for all of Georgia. Thank you.
All right, thank you very much. So what we'll do is we have a few other witnesses on the list. We'd like to hear from our witnesses today. Would ask everyone to try to limit your comments to 3 minutes, and also to try to limit your comments to the actual substitute which is before us, which does not include original jurisdiction in Superior Court. So next witness we have is Erica Finner-Sitkoff, and I'm sorry if I mispronounced your name. Oh, okay.
Good afternoon, Mr. Chairman, committee members. I am Erica Finner-Sitkoff, the Executive Director of Voices for Georgia's Children. I am also a licensed child psychologist, so I come with both perspectives here today. I want to first and foremost thank the committee and the sponsor for all the work that has been done on this legislation and the substitute bill. The greater alignment that has with all that we know with child development and the research on child and adolescent behavior. Many people spoke to the points that we were going to make, so I won't reiterate those. I'm just going to bring two pieces of data forward that I think are important for the committee to keep in mind as further discussion progresses. Currently in the juvenile justice system, about half of the children in short-term detention facilities experience a mental illness that requires ongoing treatment and support, and about 2/3 in long-term facilities require that same treatment, and about 1/3 of all juveniles that are involved in the juvenile justice system have a post-traumatic stress diagnosis disorder, a disorder diagnosis, or some similar type of diagnosis. All that to be said, given all of that, and what the Commissioner Oliver spoke about, the treatments and supports, the juvenile court is centered in rehabilitation and access to necessary treatments and supports for youth. And it is with that we support that youth are involved in the juvenile system versus the adult system. So thank you very much.
Thank you. Next, Nicole Robinson. Okay, thank you. Next, Sherry B. Williams.
Hi, Mr. Chairman.
Hi.
I'm Sherry Williams with the New Georgia Project. I want to thank all of you for the time that you've spent on this legislation. However, I have the same concerns as the Southern Center for Human Rights with this legislation. So with that, I just want to point out a couple of things. The testimony from the experts earlier today about young people and their brain development is key, since the human brain does not fully develop until age 26. So I think we need to be real careful about over-criminalizing and over-penalizing young people. All of us were young at some point and did things that were young and dumb. So we need to make sure that we have more intervention programs, as I'm echoing what several people have saying, because it costs less with intervention, and we have some budget issues here.
Ms. Williams,
my
I'm sorry
last
to interrupt
point-
you, but are you aware of in the substitute, the evidence-based intervention programs?
Yeah,
which would now be put
yeah,
in the
I'm
statute?
agreeing with that.
Yes, ma'am.
Okay, I'm agreeing with that.
Thank you.
Okay, I'm just saying we need more of that. Also, in the gang legislation that we already have that covers most of this, you heard from DAs earlier today who told you, and they are from some of the largest counties. So I'm hoping that you are really going to listen to what they had to say and put that into place. We already know that harsher penalties does not decrease criminal activities. We know this from decades of research. So that's why this new portion that includes intervention is very good. So I just want to say that your work is good, but I think a little bit more work might be what we need to make sure that there aren't any unintended consequences. That's what happens when you rush. We have unintended consequences. Thank you for your time.
Thank you. Isabel Otero. Oh, okay. Oh, no. All right. Sarah Vinson, Dr. Vinson.
Hi, thank you for this opportunity. My name is Dr. Sarah Vincent. I'm a child and adolescent and forensic psychiatrist who's practiced in Georgia for the last 10 years and the former president of our state child psychiatry organization and currently on the board of our psych organization. I first wanted to thank you for the changes that have taken place from the original version. I read that and was relieved to see the direction it's moving in today, very relieved. The only thing that I would add to the discussion, because a lot of the things have already been raised, is to make sure that we're defining gang in a developmentally appropriate way. Common identifiers may be present because of somebody being in a certain family or being in a certain neighborhood, and I would worry about children being mislabeled. And I formerly worked at a juvenile justice facility and saw kids do things with older brothers or with cousins, and how it's written now, those kids could get caught up in that. And so that's the one thing that I would add, but thank you so much for what you've done over the weekend and with your work on this.
Thank you very much, Dr. Vinson. All right, so our current posture is this. Because we had a substantive change to the underlying bill as introduced, House Bill 994, that was presented to you today as a committee substitute, but that was not a substitute brought by the sponsor. What I would propose is that if there's no objection to proceeding with this bill for consideration at this time, that we first have under consideration the substitute, and then we entertain any motions with respect to amendments of the substitute. So, Chairman Setzler.
Mr. Chairman, I'd like to make a motion that we would do pass the committee substitute LC 289699S.
So, as I said just a moment ago, if there's unanimous consent, then House Bill 994 is for consideration before this committee at this time. So the first question procedurally, in my mind, is whether the committee should proceed with the committee substitute as proposed by the chairman, or proceed with House Bill 994 as originally introduced. So at this point in time, I will call the question. All those in favor of proceeding with the committee substitute to House Bill 994 as opposed to the bill as introduced, please signify by raising your hands. Okay, one. Representative, I'm sorry, if you'd hold your hands high, please. Matt, can we get a count? 1, 2, 3, 4, 5, 6, 11, and Chairman Reeves. So it's 12-0. It's unanimous. All right, at this point in time, then the committee substitute, LC 289699S, has been referenced, or it's now before the committee. So is there we'll now recognize Chairman Setzler's motion do pass for the committee substitute. Is that it?
So moved.
All right. Is there a second? Second. All right. There's a motion, a second. Are there any amendments? Chairman Reeves.
Thank you, Mr. Chairman. I have several, most of which are simple word fixes. The first amendment I would propose is in line 68, which is the section 2 of the bill that adds gang activity to the consideration of a juvenile judge for a transfer of a case. Instead of using the word evidence of a child's participation in a gang, I believe the proper terminology would need to be evidence of a child's participation in criminal gang activity to match up with the definition.
All right, is there any objection to the first Reeves amendment? Hearing none, it is adopted.
Second amendment, Mr. Chairman, is on line 223, which is in section 5 of the bill. And it's been brought to my attention by the Prosecuting Attorney's Council in this line that it looks like E has been, there was some reshuffling of, because of adding in the two other code sections in 182 through 187. It looks like by accident, E has been now left out of what should be any person who violates subsection A, B, C, D, or E is how it should read. So I would move to strike the or and then put a comma after D and then insert or and then parentheses E.
All right, does everyone have the amendment? Chairman Silcox?
Question, Mr. Chairman. I thought that we did have an amendment back in section 3 at around line 84, the evidence-based
We'll go
amendment.
to that next.
We'll go
Yeah,
back.
and I think Chairman Efstration has that language.
Well, and I guess my other thing would be that we have so many amendments. Honestly, I really think it would be great if we could just get a new sub.
I think that
We have so
these are
many
mostly
amendments.
one-word
Okay.
amendments, so I think that
I think
that this will be easy to do.
All right, so I'll restate the amendment on line 223, strike or, insert a comma, and then after D, insert comma or E. All right, any objection? Hearing none, it's adopted.
Next amendment, Mr. Chairman, is in section 6 on line 255. Actually, I'm unclear of what, this is what Ms. Travis raised, and I am unclear of exactly what would need to be inserted here. And so what I would actually propose on this, I give my commitment wherever you are, Ms. Travis.
What was the, on line 255, what was your?
And what I would also, I'd like to look at the other code section too.
Yeah, what was your, Ms. Travis, what was your recommendation?
When an indictment is returned by a grand jury alleging criminal gang activity, then you just start at the beginning of the sentence. Any person who commits criminal gang activity in any real, so that what I read to you would be inserted between the A and the any, and of course the capitalization would change.
What I would like to do, Mr. Chairman, is look at this and before making a decision on this particular part today and have that be a continuing conversation on this. I'm not sure if I agree, and I would like to look at it.
Okay, so that's not a proposed
So I am
amendment.
not proposing that amendment.
All right, what's your
That's
next
right.
proposed amendment?
It's in section 7 on, I would propose to strike section, or lines 278 through 283. And then I would propose in the next line, 284, to change the 13 to a 12. And I've checked this section for cross-references, and I do not see any other. So I think that this will get that done.
All right, the proposed amendments to strike lines 278 to 283 and amend line 284 to 16-15-12. Is there any objection? Hearing none, the amendment's adopted.
On line 288, I would propose an amendment to change the word enterprise, to strike the word enterprise and insert criminal street gang. And this was a copy paste from the RICO Act, which is why the word enterprise was appropriate for that, but not for this matter.
All right, the proposed amendment on line 288 is to strike the word enterprise and insert the words criminal street gang. Is there any objection? All right, hearing none, it's adopted.
Line 294, same amendment, strike the word enterprise and insert criminal street gang.
All right, is there any objection? Hearing none, it's adopted.
And then the last amendment, Mr. Chairman, is the last line of the bill 417 to insert the word felony in front of sexual offense.
All right, so the amendment is in both places,
Two places.
sir?
Yep.
She recommended both places.
Where's the other one? Yes, sure.
All right, so I'll
sure,
restate the
absolutely.
amendment. Line 417, insert the word felony before sexual offense twice, where
That's
it
right.
appears each time. All right, is there any objection? All right, hearing none, the amendment is made.
That's all I have.
I'll just restate the amendment that Representative Silcox referenced, and that's lines 85 to 87, beginning with the word A in line 85 and ending with the word gang in line 87, that would all be struck and replaced with an evidence-based intervention program that has demonstrated efficacy in addressing factors that impact adolescent gang involvement. That was the amendment recommended by Department of Juvenile Justice. Is there any objection? All right, hearing none, then that amendment is adopted. All right, are there any other amendments? Representative McLaurin.
Thank you, Mr. Chairman. I actually would like to address line 255. One thing that occurred to me, and I promise in the shuffle it only occurred to me in the last few moments, is that I don't think a person can be a public nuisance. The way that this is structured right now, it says any person and real property, right, shall constitute a public nuisance. So I think at the very least, if we're going to try to make Ms. Travis's amendment, we should try to structure it in such a way so that the person's actions or omissions, where I guess in this case would be actions, criminal gang activity, would be classified as a public nuisance rather than the person, his or herself. So the way I would propose to do that is to start with Ms. Travis's amendment and do, strike any at the beginning. When an indictment is returned by a grand jury alleging criminal gang activity, the criminal gang activity of that person and any real property would be my amendment.
All right. So is there, are there any questions, or does the sponsor have any comment on that?
Yes, what I would prefer to do on that is to have an ongoing conversation with that and to look at it, but that I at this time I do not support that amendment. That does not mean that I want to look at this more carefully, and perhaps this is the best thing to do, but I'm not ready to make that decision right now. But I commit my ongoing flexibility in looking at that as this moves forward.
All right, so I think what the author's asking is for some time to work with you online to potentially present an amendment on what appears to be a pretty technical issue, but I think you're making a very good point, and I understand Ms. Travis's questions before. Is that acceptable to you, Mr. McLaurin, that you would work with him and that there would be a vehicle by which to work to address that at some other point in time?
Would be happy to work with the author, Mr. Chairman.
All right, thank you.
Yeah.
All right, Whit Bodie.
Yes, thank you, Mr. Chair. I would move at this time to amend and strike out lines 182 through 187. If you recall, Mr. Chairman, this is the language that was discussed earlier by the DAs. One of the DAs actually testified and stated that, and the gentleman, DA from Coweta County, stated that this will make it actually more difficult. The language that we have in with the intent to maintain his or her status or position in a criminal street gang, and with the intent to increase his or her status or position in a criminal street gang. Again, that's almost impossible for any trial lawyer to try to decipher. It would be very difficult for a jury to decipher if a person is trying to maintain or increase their status. So, Mr. Chair, I think an abundance of caution, and also under direct testimony of practicing DAs who are duly elected, this language should be struck.
All right, so I'll just restate the amendment as I understood. It's to strike lines 182 to 187, and just to provide legislative council the ability to clean up the numbering, subset numbering. All right, is that correct, sir?
Yes. And also, Mr. Chair, my co-counsel brought this to my attention that we still want to make sure that lines 180 and 181, everything still stays intact, and I think that's something Ledge Council
Yes.
can take care of.
Understood. Yeah, of course. I'm sorry, that was implicit in that. So, all right. So I'll just restate the amendment to leave in code or maintain or increase his or her status in lines 180 and 181, to strike the language added in 182 to 187, and to renumber and reletter. Is that correct, sir?
Thank you, Mr. Chair.
All
That's
right.
correct.
All right. Is there any objection to the amendment? There's an objection from the sponsor. All right. There's a question as to the amendment.
To the gentleman, I'm sensitive to your concerns. I think there's arguments on both sides of the question. To ask a candid question, gentlemen, is this moving us towards a bill that you're going to be able to support the underlying bill? Because again, in the spirit of trying to perfect something, I know there's always some gives and takes.
Well, Mr. Chair, respectfully, we're voting on amendments. We don't know where we are because we haven't finished with the amendments. On top of the fact that the sponsor, in all due respect, have not cleaned up two concerns that we already have, and they're going to be continued down the road. If we're voting on the bill today, I wish we could solidify those concerns today and not push that down the road. So to answer your question, Mr. Chair, I really don't know where I'm at right now.
All right. So there's a proposed amendment before us at this time. All those in favor of the Bodie amendment signify by raising their hands. 2, 3, 4, 5. All right, 5. All opposed. 3, 4, 5, 6, 7. So it's 7 to 5. It fails. You keep notes on this, please. All right. Number 19, is that Leader Trammell? Representative Kendrick.
Thank you, Mr. Chair. I would like to make an amendment to strike in its entirety line 385 and 386 and renumber it. As we heard from Ms. Travis, burglary with the intent to commit a sexual offense is something that is ambiguous and something that's unclearly defined. So my proposal is to, in its entirety, strike lines 385 and 386 and renumber accordingly.
All right, so the proposed Kendrick amendment is strike lines 385 to 386, and for legislative council to then renumber. Is there any objection?
Objection.
All right, there's an objection from the sponsor. All those in favor of the Kendrick amendment signify by raising your hand. 2, 3, 4, 5. Okay. All opposed? 7 to 5. It fails. All right. Any other amendments? All right. Hearing none, then the question is now before the committee on LC 289699S, substitute to House Bill 994. All those in favor of the substitute as amended signify by saying aye.
Aye.
Any opposed? All right, in the opinion of the chair, the ayes have it. So the bill is, moves on to rules. If you would, so there's a call for division. All those in favor signify by raising your hands. Of the due pass motion to House Bill 994 substitute as amended. All right, all opposed? All right, the bill passes. It's on to rules. I just ask that you complete the Rules Committee form and have it submitted to my office today if possible. I know it's late in the day, but need to get that finalized. I want to thank the committee members' work on this today. So the bill is substantively different from what was introduced, and I want to praise the members of the committee who've really gotten into the substance of the law today and haven't used a bill number or the politics to stop them from really working on what's the best possible policy to advance here in this legislation. And I want to thank Ms. Dotson for all of her work offline as well, preparing for today. So with that, we're adjourned.